Good morning and good afternoon, and thank you for joining Baker Hostetler's CLE webinar, COVID-19 Pandemic, Antitrust Risk and Possible Protection under the Defense Production Act and State Action Immunity Doctrine. My name is Carl Hittinger. I'm a partner at the Baker Hostetler Law Firm. I'm also the National Practice Team Leader for Baker Hostetler's Antitrust and Competition Team, and I will serve as the moderator for this webinar today. Before we start with the presentations, we have a few housekeeping items. As you know, this is a CLE credit presentation. It will last about an hour. CLE credit is provided in California, New York, Pennsylvania, and Texas. Credit's also available via reciprocity in New Jersey, and CLE credit is pending in California, Colorado, Florida, Georgia, Illinois, Ohio, Virginia, and Washington. And for other states, you can receive a certificate of attendance if you file directly with the CLE credentialing entities. During this webinar, we'll share two codes with you that you'll need to enter into a brief CLE questionnaire immediately after the program's conclusion. And so once the webinar is ended, please look for a little pop-up on your screen. Click close for your CLE quiz to appear in your browser, and make sure to answer all the questions so you can get your CLE credit. If you have any questions during the presentation, you can type them into the bar on the right side of your screen. I will review those questions and try to present those to the presenters at the end, the last 10 minutes. If we can't have time to do that, we will certainly follow up with you directly with an answer to your questions, and we will answer all of your questions. And we will also provide us with some contact information about all of us at the end if you have any follow-up questions. The COVID-19 pandemic presents challenges for all of us, both personally, we're all at home doing this, obviously, and professionally. In all the businesses that we're in, there are challenges that we have to cope with. And one of those challenges is still the antitrust laws. The antitrust laws are still on the books. They still apply to conduct that takes place in the marketplace. As you'll hear today from some of the enforcers, both the federal and the state antitrust enforcers are watching the conduct of businesses as they conduct themselves through this pandemic and the challenges it creates to ensure that the antitrust are not being violated. And why? That they're not being violated in a way that's going to hurt consumers and the public and the American economy. So therefore, the challenge is going through the pandemic in a way that's legal and proper. The antitrust laws in themselves are difficult to navigate in the first place. In this presentation today, we're hoping to provide you with some insights and best practices as to how to navigate yourself through the pandemic under the antitrust laws. And there are really two big issues. The one issue is people doing things that are illegal. They know are illegal, and they're going to get caught in the end when this is all over, when people look back and examine the conduct that occurred. But the bigger challenge is really complacency. People wanting to do the right thing, trying to do the right thing, trying to make essential products that are needed to keep America healthy and safe, and in the process of doing that, forgetting that they still have antitrust responsibilities. So we're going to go over all that today, and we're also going to talk about ways of protecting yourself and lessening the risk, both with the Defense Production Act and State Action Immunity, and just best practices how to conduct yourself. So we're not just raising problems, we're raising solutions to those problems to help you navigate through these treacherous times. So our first speaker today, we have five speakers: Stacey Papadopoulos, Patricia Connors, Ann O'Brien, Jeff Martino, and Mark Shieldcrow. And I'm going to introduce each one before they speak and give you a little background on them. Stacey Papadopoulos is the General Counsel and Senior Vice President of Operations and Initiatives for the Consumer Brands Association. The Consumer Brands Association champions the industry with products that Americans depend on every day: household and personal care, food, beverage products, and that is their mission, to deal with those issues. Stacey is the General Counsel of that association, and she's going to speak to you about the perspective of people that are members of her association and the challenges that they're facing in this pandemic. Stacey?
Thanks, Carl. In the next few minutes, I'm going to provide some context and perspective for the important legal issues we're going to discuss later in this webinar. Starting with the industry perspective, Since this crisis began, Americans have been stocking up on cleaning supplies, personal care items like toilet paper, and non-perishable food and beverage products to prepare for and protect against the virus's impact. And associations like Consumer Brands have been working with industry to ensure that companies can keep producing and consumers continue to have access to the products that keep them healthy and safe. This means three things from our perspective. First, making sure employees can work and, importantly, do so safely. Second, keeping manufacturing plants and stores open. And third, maintaining supply chains. Some of the relevant actions we've taken along with other organizations have included ensuring the CPG industry is part of the country's critical infrastructure. More recently, after DHS declared the industry to be essential, we've been advocating that all state and local governments embrace the DHS standards for critical infrastructure. These standards encourage the exemption of grocery stores and CPG manufacturers from gathering bans and curfews, provided such facilities follow worker safety guidelines established by agencies like the CDC and OSHA. Making these ongoing exemptions uniform across the country ensures the industry can continue manufacturing and that consumers have access to the products they depend on. Next, the highest priority for the industry is ensuring employee and product safety. Companies are taking every precaution following guidance from federal, state, and local agencies. CPG employees have answered the call to keep the country running and to continue to do so. All essential workers, be that in healthcare, manufacturing, and beyond, must have access to the personal protective equipment they need to serve public interest safely during this crisis. Unfortunately, competition for PPE is significant, even for thermometers and masks that are not N95 masks, and you're seeing that competition for goods play out at a local, state, and international level. Finally, on the supply chain, our focus has been on preventing disruptions that impact the availability and affordability of essential products and ingredients needed to make those products. That involves, at a domestic level, keeping the freight system, trucking and rail, operational and efficient, and on a global scale, encouraging the administration to swiftly oppose foreign countries imposing bans on exports of critical materials and supplies. An early example was India's restriction on acetaminophen, which thankfully was retracted since India produces about 90% of the world's supply. Now, switching from the industry to a consumer perspective, consumers care about availability, affordability, and accessibility of goods. When this crisis began, one of the first things you saw was hoarding and price gouging. Consumer Brands reached out directly to U.S. Attorney General William Barr, quickly took action to help stop price gouging by activating the National Center for Disaster Fraud to coordinate federal and state agencies and support the state attorneys general. There are plenty of bad actors out there that want to take advantage of a crisis. You see that often with online third-party resellers charging ridiculous amounts like $149 for a bottle of hand sanitizer or $45 for a container of wipes. Consumers don't want this, and the manufacturers of these products don't want it either. Another trend we've seen on price gouging has been its expansion to cover more categories of goods. It started with hand sanitizer and wipes, then moved to include toilet paper and other paper products, then on to other personal care items like diaper and formula, and now includes shelf-stable items like canned goods. There are legitimate reasons for price increases, which can include a limited supply or an increase in the cost of packaging materials and product ingredients. For example, you probably heard or seen stories about the increase in the price of eggs. Other things to keep in mind as you think about the supply and demand for consumer goods are that consumers are being encouraged to limit the number of trips they take to the grocery store and therefore stockpile goods. Further, as Americans stay home and make food at home, the demand for food and commercial service items, those items bound for restaurants, hotels, schools, and the like, has dramatically decreased while consumer demand has increased. And when you think about it, the sizes, labeling, and manufacturer of consumer versus commercial goods are usually very different. Next, for the most part, the CPG industry had been operating on a just-in-time or lean manufacturing principles that really depend on efficient global supply chain. And last, while manufacturers shift lines if they can to produce high-demand items and other industries step in, it takes some time to get the regulatory and other pieces in place. For example, you've probably seen or heard now that distilleries are making hand sanitizer and car companies are making ventilators. Let's see, Consumer Brands has been conducting weekly consumer surveys since the crisis began. And before I turn it back to Carl, I wanted to share some highlights. On this first slide, you can see that consumers are still concerned about access to products. However, with the exception of household cleaning supplies, consumer concern has stabilized or begun to decline. Next slide. On the positive side, the majority of consumers are well stocked, with 80% reporting that they have more than a week's worth of essential goods. Next slide. Further, a majority of consumers have started to see or found more availability of high demand goods like toilet paper. And then next slide. And though consumers are more able to find products, the number of consumers that have personally seen price gouging continues to grow, now up to 52%. Thanks, Carl. Now I'll turn it back to you.
Thank you, Stacy. That was very helpful from your perspective on behalf of your various members. The next speaker is Patricia Connors. Trish is with the Florida Attorney General's office. She's the Chief Associate Deputy Attorney General, overseeing the office's enforcement units, including antitrust and consumer protection. She's been there for over 30 years, and she supervises most of the major enforcement initiatives undertaken by that office. Trish?
Thanks, Carl. I appreciate the opportunity to talk about what the states are doing with respect to price gouging enforcement. Of course, I must start with the standard disclaimer that my remarks are my own and should not be attributed to the Florida Attorney General, the Florida Attorney General's office, or any other state Attorney General. Florida, of course, is no stranger to this area, with declared states of emergency triggering our price gouging laws during hurricane season almost perennially for the last 15 years or so. But if you don't live in Florida or do business here or in any other state that has not recently experienced a natural disaster of some kind triggering these laws, I have no doubt that this is territory that is a bit of a mystery. So let's start with what is price gouging. There are a lot of different definitions you'll see, but essentially it means when a product or service that is typically deemed to be essential or a necessity is unjustifiably excessively priced when it's compared to some relatively objective measure. By my count, there are roughly about 36 states, including D.C., and at least 2 territories with price gouging statutes, and there are at least 2 additional states, Massachusetts and Missouri, where the state attorney general has promulgated the prohibition by rule, so you'll find it in their administrative code. In addition, some state governors with no price gouging statutes have recently issued executive orders allowing their states to pursue price gouging during the current emergency, and Maryland and Minnesota are the 2 that I'm aware of. And then in Illinois, the governor issued an order extending the state's authority to pursue price gouging into household and medical supplies, taking the existing Illinois law's applicability beyond solely petroleum products. While there are some similarities between price gouging laws, there are a lot more differences. As you can see in this first slide, most typically price gouging laws are only triggered by a declared state of emergency or an occurrence of a natural disaster or an abnormal market or economic disruption. Some statutes, like those in North Carolina and California, apply comprehensively across a broad range of products and services, and others only apply to single products or a handful of products deemed necessary to a consumer's health and safety in an emergency. Most of the statutes, though, are broad enough that the emergency itself dictates what can be deemed an essential commodity. Some state laws apply to just retailers, and others, like California, apply to every part of the distribution chain. Some make price gouging a criminal offense. Again, that's California, where it's a misdemeanor. Others, which are most of them, only provide for civil remedies such as civil penalties, restitution, and injunctive relief. Some have time limits during which the price gouging laws apply, and that usually can be extended, and others have no time limits. And I should note quickly that states are not the only ones passing and enforcing price gouging laws. New York City has them on the books. Miami-Dade and other large metropolitan areas are not only passing ordinances, but in many cases very aggressively enforcing them. And New York has already leveled tens of thousands of dollars in fines and initiated several lawsuits against repeat offenders. Now, there are different thresholds as to what triggers a price gouging situation. This next slide shows there are 3 specific categories that have generally been recognized by the commentators. The first is the percentage increase cap. States like California, New Jersey, and Pennsylvania, and most recently through its executive order, Maryland, use a set percentage above which a seller cannot increase a price without potentially being deemed in violation. California, New Jersey, and Maryland set their percentages at 10% above a pre-event price, and Pennsylvania sets theirs at 20%. The second category is the unconscionable price limit. There's at least 16 states, including Florida, that use that standard. Others include Alabama, New York, and Texas, to name a few. Florida defines this as a gross disparity between the price 30 days before the event and the post-event price, but other states have other definitions. The third category is just the outright ban, and these are less than 10 states that just ban outright price gouging. Georgia, Connecticut, Louisiana are a few examples there. In those states, any increase in price after the declaration of an emergency may constitute price gouging, any increase. With respect to all of these, most states have exceptions if a merchant can show that it was just passing on the increased cost to the merchant of the product or service along with the normal margin for profit. So that was a lot to cover, but the main elements of a claim, to summarize, would typically include, in most states, as the next slide shows, whether there had been a state of emergency declared, whether the product in question is named in the statute or could be considered under the circumstances to be an essential commodity, whether the price of the product appears to be excessive or exorbitant or fall outside of the designated percentage threshold for states that have those percentage caps. And then the laws would not apply in most instances if it can be shown that there are any justifiable costs that might offset any excessive increase in price. So that last part can't really be emphasized enough for those of you representing retailers in particular. The best advice you can give is to make sure first and foremost that your clients maintain their documentation. They need to demonstrate the reasons for any price increases if there's some scrutiny. It will be helpful to transparency in the long run and probably save a lot of time as well. So what are the states doing? The coronavirus caused states to have to really quickly pivot in just trying to determine what products are necessities in these circumstances. You know, in a hurricane, it's pretty simple to see. It's typically water, gas, ice, and hotel rooms before a storm, and generators, cleanup materials, tarps, and building materials after. And here it's hand sanitizer, face masks, PPEs, test kits, and in some states, food and toilet paper. With this crisis, beginning in March, after the hoarding had taken its toll on the retail shelves everywhere, many states began receiving numerous complaints about exorbitant prices on the major platforms for things like hand sanitizer, face masks, and disinfecting supplies. In response, 33 state AGs sent a letter to Amazon and some of the other big platforms and about the need for aggressive policing of price gouging. And some states like Florida and California sent separate letters. Amazon said they were partnering with law enforcement at all levels and had proactively reached out to at least 20 AGs, including Florida, California, and New York, among others. In fact, that is true. Amazon provided the Florida Attorney General's office with 44 examples of egregious third-party seller situations that we immediately followed up on with subpoenas and have since sent nearly 20 more, mostly to Florida-based sellers. Amazon also said they were policing their platform by using an automated system that continuously compares prices submitted by their sellers with current and historic prices within and outside of the Amazon platform. So they've taken down hundreds of thousands of sellers or otherwise suspended them. Other platforms like eBay, Facebook Marketplace, and Walmart.com are doing similar things. In addition to using automated block filters, eBay has added 30 new employees to do manual sweeps and takedowns. And as of March 23rd, when they wrote their response, they had blocked or removed over 500,000 listings. They have also implemented an online consumer complaint system where consumers can directly contact them about concerns. And Facebook is policing not just its marketplace platform, but it's also taking down ads it spots for excessively priced commodities on its social sites like Facebook and Instagram. So to give you an idea of complaint volume at the state level for Florida, it is as robust as during any major hurricane, I would think. We've had, as of this morning, nearly 7,000 consumer contacts with our office, with about 2,600 of those dealing with essential commodities. Nearly half of those deal with complaints about third-party sellers on one of these platforms. So we respond to these as quickly as possible to get the post removed. We work with our contacts in those corporations. We often get refunds very promptly, and we send warning letters and preservation letters to third-party sellers and to brick-and-mortar businesses where we have complaints. In some instances, we've begun working up assurances of voluntary compliance, and as with just about every price gouging event we've encountered, there likely will be some formal complaints filed. Other states are doing much the same, issuing warning and cease and desist letters, and in some cases, they're sending investigators to local businesses. In an interesting twist, it looks like Alaska, a state with no price gouging statute, has turned to its general unfair trade practices statute and is among the first to file a formal complaint alleging unconscionable conduct for excessive pricing. There, the AG has sued an individual who apparently ran around to the local stores like Lowe's and Home Depot, purchasing hundreds of 20-pack boxes of N95 masks that normally were priced around $21.98 a pack, and then selling them on eBay and Amazon for up to $90 a pack. The AG is seeking restitution and civil penalties of $25,000 for each and every posting. So for a quick overview of what the states are doing in almost real time, it's being updated constantly, you can go to the National Association of Attorneys General website at www.naag.org, where they list by state press releases and links relevant to price gouging and consumer protection laws. And with that, I'll conclude my remarks. Carl, thank you, Ann, Jeff, Mark, and Baker Hosteller for the opportunity for me to give this brief overview of what the states are doing.
Trish, thank you very much. That was extremely helpful to show the perspective of the state attorney generals, particularly the Florida Attorney General's office where you work. It just shows you how there's great scrutiny being placed at this time by the state authorities, both real time now and obviously when this is all over, what they're going to look at looking backward. Next, I'd like to introduce one of my partners, Ann O'Brien. Ann is a partner in our Philadelphia and DC office. She just left the Department of Justice Antitrust Division, where she spent 20 years there in numerous senior leadership positions, including assistant chief of 2 sections, and then she was the acting director of criminal enforcement. At one point, she was involved in all the enforcement decisions, leniency, immunity, all those things. And if she was still there, I'm sure she'd be investigating these issues that we're talking about today. But we have the unique opportunity here to have the perspective of Ann, and then followed by my partner, Jeff Martino, who's also at the Department of Justice, to see how the federal authorities are now looking at these issues. So Ann, I'll turn it over to you.
Thank you, Carl, and thank you to all of you for taking time to join us in these challenging times. We're really lucky to have Trish's 3 decades of experience to distill down state price gouging for us. And that's a lot to distill down. And I don't know anyone who does it better. So thank you, Trish. The antitrust policy nerd in me has to start by saying that, price gouging is of great public concern in times like this, but it's also very tricky from an antitrust perspective. Under antitrust and free market principles, businesses are typically allowed broad freedom over the prices they charge for their products. And price gouging laws curtail that freedom during emergencies like the one we're facing now, and set price caps on essential products like Trish described. Many economists and antitrust lawyers view price gouging laws suspiciously and more really as consumer protection laws that don't promote competition and free market principles like the antitrust laws are aimed at. And there was a very interesting article in The Economist last week on that very topic. It also highlighted one additional concern, and that might be of interest to all of you, and that's that these price type caps and price gouging laws might actually disincentivize companies bringing more essential products to markets or entering into these areas where they are badly needed. So I'm going to focus on price gouging at the federal level, which really is distilled into this left-hand column on slide 17 that we have up. And like Trish, during my 2 decades at the Department of Justice, we saw a lot of price gouging concerns, usually prompted after natural disasters like hurricanes. And they usually focus, as Trish mentions, on gas prices and other products like water that were essential and building materials after hurricanes. Now we face a very different situation. Price gouging was in those situations was primarily a state issue, and now it's not only a state issue. There's no specific federal price gouging law now on the books, but we are obviously seeing unprecedented concern at the federal level about both hoarding and price gouging. And 3 things have really come together to put this on the federal radar and make hoarding and price gouging, in fact, federal crimes. And so here's what's happening on the federal level, and I will say it's changing every day. The 3 things coming together were first on March 23rd, the president issued an executive order aimed at preventing hoarding and price gouging. The executive order invoked the Defense Production Act, and for certain scarce products that were later designated by HHS, they make it a crime for individuals and companies to accumulate these items, either 1, in excess of reasonable needs, that's the hoarding piece, or 2, for the purpose of selling them in excess of prevailing market prices. And that sounds like price gouging, although I'm not sure what the prevailing market prices specifically is not defined, and I'm not sure how that will play out. We will see. Under the Defense Production Act, these are misdemeanor federal crimes, punishable by up to a year in jail and a $10,000 fine. AG Barr appeared at the daily coronavirus briefing that day, March 23rd, and he really had some harsh words saying enforcement would be aimed at people hoarding these goods for the purpose of manipulating the market and ultimately driving windfall profits. And the feds would be knocking on the doors of those hoarding essential supplies like masks. Now, AG Barr was very careful to say, if you have a big supply of toilet paper in your house, this isn't something you have to worry about. But the actual statute doesn't spell that out. So that's an area of prosecutorial discretion. There was also a memo issued on March 24th that AG Barr issued. There's a link to that in this PowerPoint, spelling it out a bit more, although it doesn't contain further guidance on what prevailing market prices would mean. And as a former prosecutor, I wonder how the elements of that misdemeanor offense would be pled and proven to a jury beyond a reasonable doubt. And that certainly remains to be seen. The DOJ also formed a COVID-19 hoarding and price gouging task force led by the U.S. Attorney in the District of New Jersey with the assistance from the Antitrust Division's criminal program. And it said that each U.S. Attorney's office must designate an experienced attorney to serve as a member of the task force. So the task force alone shows that the federal government will be looking at this issue, and there will be people designated to look at it around the country. Then the last piece came into play on the March 25th when HHS designated the scarce materials covered under the executive order. And the link to that list is also in the PowerPoint. As you would expect, it focuses on essential medical supplies and equipment like respirators and ventilators, N95 masks and other PPE, certain disinfectants, and believed to be COVID-fighting drugs. It does not include retail products like toilet paper or food items. Things like fuel, water, and building supplies that have been deemed essential for prior hurricanes are obviously not so far subject to the concern of this pandemic. The HHS order lasts for 120 days, but it can be extended. It's COVID-19 specific and triggered by the president's executive order. So when that goes away, for this federal law will not be on the books. We have seen some articles about the recent introduction of House COVID-19 specific price gouging laws, and there was a previous Senate bill that would prevent pricing abuse in times of emergency, and we'll watch how those continue to move, but they have not moved in the last week. Finally, at the federal level, anti-hoarding and price gouging concerns have already led the FBI to the door of at least one person and resulted in his arrest. On March 30th, a Brooklyn man was arrested and charged by complaint with assaulting a federal officer and making false statements. The man was under investigation for hoarding scarce medical supplies, including N95 masks, and attempting to sell them at a markup of 700%. The criminal charges actually included assault for coughing on the arresting agents while claiming he had COVID-19 and false statements, and did not include charges under the DPA. Trish did a great job covering the state price gouging law, so I won't go over those again. The one point I'll make here is that I know many of you want to know, is there a safe price to sell essential items at? Unfortunately, the standards for what's considered gouging vary a lot, as Trish described. There's no safe harbor for price increases that guarantee you won't face scrutiny in any state for essential products. Typically, there are exceptions, as Trish described, for price increases that can be tied to actual costs, including labor. So the safest route is to focus on your costs and then build in typical profit margins above those costs to reach prices and document that. Focusing on maintaining margins over costs rather than bottom line pricing is a safer pricing route in these times. So we can't say an increase of 10% is a safe harbor. You have to ask from what. So looking at past pricing is very helpful. Next slide, please. So price gouging versus price fixing. We've gone over what price gouging is. Price fixing is not unilateral. Price fixing is an agreement on price between horizontal competitors. It's not tied to a specific emergency like the price gouging laws. And it's typically enforced at the federal level by the DOJ Antitrust Division criminally, and it may also violate state laws. So while both price fixing and price gouging carry civil and criminal penalties, price fixing has by far much harsher penalties, up to 10 years in prison for individuals, very large fines, potentially private lawsuits. These are company-threatening, life-altering penalties. We always say that desperate times call for desperate measures, and we expect that as competitors collaborate in these emergency times, there'll be more temptation to talk about prices and even the forming of some crisis cartels in some non-booming industries, perhaps with oversupply. So radar should be up for these type of collaborations that may cross the line to price fixing. Next slide, please. So just to put it all in one map, this is a map of states that have price gouging laws. As you can see from the red highlighting, the vast majority of states do have these types of laws, not as much in the mountain state area. In the last month, there have been many reports of state and local governments investigating and charging sellers under price gouging laws. Trish highlighted some. This slide highlights just a few more examples, although there are a number of them. And as you can see, it's likely that regulators are going to go after more egregious conduct. Mostly, you'll see where price increases are 100% or more. You see the closest one in New York, 150% price increase, and on hand sanitizers, and we've seen some on cleaning supplies as well. We continue to monitor these enforcement actions and look for what are the state and federal authorities interested in the price gouging realm, because that helps us to better gauge our advice in deciding and advising on prices. Next slide, please. So the important question for all of you, how do you avoid price fixing and price gouging? My colleague Jeff Martino will discuss it more, but in terms of avoiding price gouging, the number one key to avoiding price price fixing, is to always, always, always set your prices independently. No collusion, as we hear a lot these days. Avoid communications with competitors. When companies do communicate, understandably, in these difficult times, and interact directly, be very careful not to discuss prices or any other competitively sensitive information, such as costs, customers, or how you are pricing, how you come up with your pricing models. Price gouging, on the other hand, is the trickier one. The biggest point here is really knowing that these laws are out there and being enforced. In our free market, we typically assume that you're free to sell your products at whatever price the market will bear, and that's usually a good assumption. But as with all things right now, these times are the exception. It's important to avoid taking advantage of a situation or looking like a profiteer. It's much harder to figure out what a profiteer looks like. The other key thing here is that sometimes you have to increase prices significantly because your input prices or costs are going up dramatically. So it's important that you keep good documentation of those increases. As Trish mentioned, nearly all of the price gouging laws have some sort of exception where the seller can prove that price increase was proportionate to the increase in input costs. It's very important to document this. Finally, I want to note that the direct fines and penalties under these price gouging laws are not the only risk. Even if your company is not trying to take advantage of the situation, trying to do the right thing, downstream resellers might be trying to take advantage. And if they do, the bad publicity and reputational harm could come back to the manufacturer or anyone in the chain of distribution. Just last week, a manufacturer of masks filed a complaint against an unauthorized reseller who is attempting to resell their products at a 500% increase. So that is a new area of concern that we're seeing in this crisis. I'm sure we'll continue to see developments in this area. But thank you for your time. Turn it back over to you, Carl.
And thank you very much. That was an excellent perspective, particularly from the Department of Justice and how they are presently looking at this, and they mean business. Clearly, we've seen that. Our next speaker will be Jeff Martino. Jeff is also a partner at Baker Hostetler. He works out of our New York and our new San Francisco offices. He spent 2 decades as well with the Department of Justice, and when he left, he was chief of the Department of Justice Antitrust Division office in New York City, where he oversaw the 25 different prosecutors looking at all sorts of antitrust conduct, particularly collaborative conduct. And so today, he's going to talk about competitor collaborations. And the 2 points I would make that Jeff is going to address here are 2 things that always come up in antitrust analysis, which is one, the follow the leader mentality, where somebody increases their price and other competitors follow. As you can see from Ann's presentation, following the leader of a price gouger leader could lead to suspicions of more than just price gouging. It could lead to conspiratorial conduct. And the other issue that Jeff's going to talk about in terms of collaboration is supply of essential products. After this is all over and people look back at this, and they're looking at it now, the question is going to be asked, why weren't suppliers of essential products making more product? And maybe they have justification for that. Maybe there's good justification for that. But that question will be asked. And if people during a pandemic are all holding back on supply production, raising prices in a gouging way, those are the things that lead to antitrust investigations after this is over and lead to private litigation. So with that, I'll turn it over to Jeff to talk about competitor collaborations and how to avoid problems that we're talking about now. Jeff?
Great, thanks, Carl. And it's a pleasure to be on with Stacy, Trish, Ann, and Mark Shilkraut to follow. As Carl's mentioned, I am located in New York and San Francisco offices, and currently at home in the Westport, Connecticut office, where our managing partner is my first grade daughter. She's very demanding, but kindly agreed to share her bedroom with me so I can at least the office in her room so I can talk to you today. And on the East Coast, we're having quite a storm, but hopefully everybody is safe and healthy. As Carl's mentioned, before joining Baker in September, I was chief of the New York office for about 5 years. And in previous roles, and in that role, I gained firsthand experience with investigation and prosecutions, that did come out of crises, and those crises cartels, as Ann has mentioned. They arose out of natural disasters as well as the Great Recession. I've been part of the enforcement efforts and strike forces and task forces. And while at the division, Ann and I were both involved in some of the first matters to give companies credit for their compliance programs and sentencing. And Ann was heavily involved with the development of the compliance guidance that the division recently rolled out last summer. So given my experience and our experience in these areas, I'm going to touch on a few points briefly before turning over to Mark. First is a discussion about competitor collaborations that are appropriate and lawful during these difficult times. Then a discussion of when those collaborations rise to collusion, perhaps raising criminal antitrust risk, and then compliance measures that may address these risk areas. Next slide, please. Okay, yeah, this is the right slide. Well, shortage of key supplies, particularly PPE and ventilators, has been a major concern in the fight against this virus. And while antitrust laws typically encourage and enforce competition among competitors, the antitrust laws certainly recognize that collaborations can be beneficial in certain circumstances. And the scope for permissible collaborations is likely broader during a time of emergency like now. My colleague Mark will go into a little more detail later on what's most likely permissible and under the Defense Production Act as well as state immunity doctrine. But the point is that in times of emergency, the normal mechanism for distributing critical products by having competing independent supply and competing customer demand may not be the best way to allocate resources. Federal antitrust agencies recognize this. On March 24th, FTC and DOJ put out a joint statement recognizing the potential for collaboration in order to fight the crisis and indicating that they would be expediting reviews of collaborations under their business review process. Next slide, please. All that being said, though, it's critical to know that the antitrust laws are still in full force during this time. Businesses across all industries are feeling intense pressure. This goes for businesses involved in the supply of key products, but also for businesses that have seen their revenues dry up, almost to lockdown and social distancing measures that have been put in place by state governments and local governments. Under such intense pressure, companies can become desperate in trying to come up with ways to respond. And anecdotally, I've heard companies want to take the approach of let's deal with what we need to now, and we'll litigate later if need be. But in these crises, it is per se illegal to agree with your competitors on prices, including refunds, output, or capacity. It is also illegal to agree with competitors on where to sell or not to sell, or what products to sell or not to sell. These laws remain in place, and as Ann mentioned, the penalties on the criminal side is up to 10 years in jail for individuals, but there's also civil fines, private lawsuits with total damages, so the exposure can be high. Next slide, please. Based on its actions during and after past emergencies like Hurricane Katrina, the federal antitrust enforcement is going to be focused looking for any activity that involves fraud or abuse that takes advantage of the crisis. It sounds like common sense, but I think we all want to continue to be reminded of that. And the agencies have aggressively pursued wrongdoers by first designating significant resources to enforcement efforts designed to detect and prosecute those violators. Second, sharing knowledge, data, and best practices across agencies, state and local. And third, supporting efforts to enhance public awareness to encourage reporting of the violations. Some specific examples include the Market Integrity and Consumer Fraud Task Force, which has a mandate to combat fraud against consumers, and the recently established Procurement Collusion Strike Force, headed up by the Antitrust Division, which is likely to have a key role given the federal government's significant purchaser of medical equipment during this time. Next slide, please. So whenever we talk about compliance, the focus is going to always be having the right tone at the top to create a workplace environment that is proud of being a good, law-abiding corporate citizen. By auditing high-risk areas where competitor contacts are frequent, a company can prepare itself to establish protocols to address the antitrust risks. To the extent companies do participate in collaborations with competitors, here are some key do's and don'ts that are listed on the slide. The first and most important point is that these collaborations need to have a legitimate pro-competitive reason. That reason may be to help get more products to those in need quicker, but the reason cannot be to increase prices or protect your market share. Some basics are always make an agenda for the meeting. Topics should be narrowly tailored to only advance the collaboration at issue. And when at the meeting, discussion should stick to the agenda. It's typically a good idea to have antitrust counsel present at such meetings so they can be consulted as to what is okay or not okay to discuss. Avoiding one-on-one meetings between employees and your competitors' employees is always a best practice. Avoid exchanging competitively sensitive information with competitors. That includes prices, margins, costs, anything that your competitors might use to change their competitive strategy. If you believe exchanging such information might be necessary for the collaboration, it's wise to seek counsel before doing so. If improper discussions do take place, your employees should know how to make a noisy exit. They want everyone at the meeting to know that they've objected, why they're objecting, and that they will be leaving. But now meetings between competitors can be legitimate, and the line may be gray, so employees may not want to make their objections known so conspicuously. And so having a hotline for complaints provides that safe harbor to employees and gives notice to the company to try to get ahead of any issue. Next slide, please. So to round out the forms of conduct that have criminal antitrust implications, in addition to price fixing that Anna's discussed, we want to provide some quick specific guidance with respect to bid rigging and market allocation that is similar to what's been addressed before. Two keys to always keep in mind that underlie compliance with the antitrust laws is one, make your pricing, bidding, and strategic decisions independently where possible. Be especially cautious and vigilant when interacting with competitors. So at this point, I'll turn it back over to Carl, and thank you for your time, and be safe and healthy, everyone.
Jeff, thank you very much. At this point in the presentation, mostly to the civil side, Ann and Jeff talked about the criminal risk that people facing with these antitrust. But there is always the civil antitrust risk, things we've talked about before. Civil penalties for this, with class actions and such, and again, after this is over, could be considerable, could be company-breaking kind of lawsuits. And therefore, it's really critical for people to be keeping an eye on their conduct now and reaching out, particularly to the government, as Mark's going to talk about, to get protection and lessen those risks. This is not the time to be a lone ranger. This is the time to be a good citizen. And so with that, I'm going to introduce Mark Schildkraut. Mark is my partner in our DC office. He was formerly Assistant Director of the FTC's Bureau of Competition. And while the FTC did a number of investigations, hundreds actually, of all types of mergers, including Microsoft. So Mark, I'm going to turn it over to you. Mark?
Carl, thank you very much. I'm going to be talking about civil antitrust exposure, and let's go to the next slide. And I will be talking about the antitrust protections, immunities, defenses that people may have to exposure, and I'm going to be talking about what civil antitrust exposure you may actually have in responding to the pandemic. Next slide. So Jeff's already talked about the fact that on March 24th, the DOJ and FTC issued a joint statement highlighting the important role of collaboration in fighting the pandemic. They listed a number of pieces of conduct where which were unlikely to be problematic: R&D collaborations of certain types, sharing know-how necessary for certain collaborations, standards for patient management, many or most joint purchasing agreements among healthcare providers, healthcare facilities working together to provide resources and services, businesses combining production or distribution to distribute medical supplies, and obviously joint lobbying of federal emergency authorities are protected by the First Amendment. Let's go to the next slide. So there has already been a expedited business review letter. Both the FTC and the DOJ promised to do their reviews within 7 days, and this was a request by McKesson, Cardinal, and multiple others. And what the response to the request was that was for the DOJ to say they're working together to expand existing capacity and bring goods to communities in need was acceptable to DOJ at this point in time because of the limited duration of the collaboration and it necessarily addressed COVID-19 related scarcity. And the one thing to point out about an expedited business review letter or an FTC advisory opinion, all they're saying is that the DOJ has no intention of suing and the FTC has no intention of suing. It doesn't really protect you from a third party suing, but it would be fairly influential when presented to a judge if you were sued. Let's go to the next slide. The EU Commission has also responded to the pandemic, and basically companies are responsible for assessing for themselves the legality of their agreements. In most cases, the Commission will find oral guidance to be sufficient. The Commission will provide comfort letters in exceptional circumstances, and it's already provided one letter. Next slide. So there are a number of potential defenses out there. They're not easy to get. One is under the Defense Production Act. The act was enacted in 1950, later expanded. And what's important for us here is that the act permits the executive branch to develop voluntary agreements and plans of action among industry participants to address emergency needs. Now, these voluntary agreements and plans of action will give you a defense to an antitrust dispute so long as the plan responds to the pandemic and is submitted to Congress. The DOJ, upon consultation with the FTC, certified that the objectives of the plan could not be achieved, by less anti-competitive means, and the DOJ and the FTC must monitor the conduct to cover the plan. But that is one potential way that you could get a defense for particular action. Next slide. There is another act called the Pandemic and All Hazards Preparedness Act. I'm not going to spend a lot of time on this because it has not been implemented yet, but it does grant antitrust protection for participants in certain meetings with the HHA secretary, and the agreements that are created under it must avoid substantial anti-competitive effects that are not reasonably necessary to achieve the contemplated benefits in the agreement. Next slide. So we're going to do a little bit of analysis under the antitrust law. There are like three categories of analysis: per se, rule of reason, and quick look. So per se is conduct the courts have so often condemned that few defenses are available. Rule of reason is conduct that can be anti-competitive under certain conditions, but not under all conditions. And there are a wide variety of defenses under the rule of reason that don't apply under the per se rule, where the court is unlikely to listen to many arguments, such as the prices we fixed were reasonable prices. There's also quick look, which is somewhere in between per se and rule of reason. If an action looks inherently suspect but is something new, not typically in one of the per se or rule of reason categories, the burden shifts to the defendant to prove pro-competitive justifications, and it could lapse into a full rule of reason analysis. Per se is things like price fixing, bid rigging. You've heard from Ann and Jeff on that. Rule of reason are generally vertical restraints, some tying arrangements, which are primarily vertical, joint ventures, information sharing, and things of that nature. Next slide, please. So we have two hypotheticals here. I'm actually just going to go to the second hypothetical, so why don't we move to the next slide? This is a market division agreement. Healthcare providers offer specialized critical in-facility care to multiple patients on a regular basis, providing services to COVID-19 patients may risk spreading the virus to other patients in the facility. So under my hypothetical, in order to protect patients, competing providers divide the patient pool, with some competitors specializing in COVID-19 patients and some others treating the remaining patients. In ordinary times, this would be seen as a market division agreement that is typically per se unlawful, and regulators would be unlikely to approve of such an approach in a business review letter or in a Federal Trade Commission advisory opinion. But during this crisis, the market division here enables the separation of COVID-19 patients from other patients, limiting the spread of the disease. The cooperation is likely to be seen by regulators as necessary and beneficial. So this might be a good place to ask the FTC or DOJ for a review. Next slide. You'd want that review in order to help you in a civil lawsuit. As Jeff has already said, you're exposed to treble damages. Actually, maybe Ann said that. And there are attorney fees, but damages can actually be higher than that. They can have multiple classes, can attain damages that are not offset. Both federal enforcers and state attorney generals can seek fines or consumer redress as well as injunctions. Let's go to the next slide. So applying the rule of reason, do firms really need the blessing of DOJ, the FTC, or need various emergency acts to immunize conduct? If the conduct truly reduces the ravages of the pandemic, the firms would have a strong argument that the benefits outweigh the costs, so long as it's the least anti-competitive means of achieving the beneficial results. Next slide. So, in conclusion, in per se cases, do not expect the courts will give a pass to per se conduct, even if it's in response to a pandemic. In our hypothetical, it might be unlawful for specialized competing healthcare facilities to divide up patients, and this may be a good place to try to form an agreement for an antitrust immunity, or at least get a business review. Under the rule of reason, defendants may have better success using the pandemic as a justification if the conduct clearly falls into the rule of reason. But even in such cases, business review and advisory opinions or limited immunities allowed by some of the statutes would certainly be an additional weapon in the defendant's arsenal. Carl, thank you.
Thank you, Mark. That was very helpful and provides people with some answers to questions. This is not a problem. There are solutions. And the solution, of course, is working with the government. As you can see, like everyone else has to work with the government during this pandemic, people can work with the government and can get relief and approval for their conduct. This is not the time to be going it alone. We have a few minutes left, and let me ask some questions of our presenters. Let me go to Trish with a question for you as a state prosecutor. We talked a lot about price gouging. You've talked about it from a state level, and talked about it from a federal level. And you in your career, I'm sure, have experienced what we'll call the follow the leader pricing, where somebody increases their prices in the marketplace and other people follow. And in defense, typically as well, this isn't collusion. We're just following price of our competitors in a competitive market and matching their price. And that doesn't show collusion. In this situation where we're talking about price gouging, where people are charging excessive prices, without revealing any of your investigations now, but just as a general question, have you found or seen situations where there's price gouging by a particular supplier, and then other competitors are following that price gouging and going along with it? Or have you found these price gouging situations to be kind of long ranger situations where somebody raises their price, but the other competitors hold back with competitive prices? What have you seen so far?
Well, I have to speak to my entire experience in states of emergency, because in this one, I don't believe we've seen that yet. But in Florida, but in the broader arena of price gouging matters, there have been times when the market wasn't operating in the way that you would expect it to operate in a situation where there was a state of emergency where prices generally stay stable, around what the price was 30 days before the emergency, at least if people are careful about doing it, which in Florida they've learned, I think, to do that. And I've seen it more in where there's been a major market disruption, like a lot of devastation that has kind of skewed everything. So there's all these different factors and elements that come into play that aren't your normal market conditions to begin with. So there's been instances where we have had suppliers that are not performing in the way that you would expect with respect to what you know the cost to be to them at the time. It may be that in a particular area of the state they are staying at prices as a group that are different from the surrounding areas that might be supplied by the same supply chain. So in those instances, we do look at it both as a price gouging and a price fixing potentially situation. And we have both of our consumer protection and our antitrust people look into it. And of course, we have to look for evidence of an agreement, and we'll do what we need to do to investigate that. Obviously, in these situations, for the most part, to the extent that you can show that costs did not go up and prices do go up at the next level, someone who's trying to be the market leader with a follower behind is going to get questions from a price gouging perspective. But that's the easiest way to at least initially look at a matter. As we all know, price fixing investigations can take a little bit longer. So in either event, it's dangerous territory to tread into, at least in states with active antitrust enforcement units, because it's not just the price gouging element that should keep everyone in the market at stable, if you will, prices that are comparable to those prior to the state of emergency, unless there's been an increase in costs. But there's also going to be some issues concerning whether the prices have been fixed if those anomalies stand out significantly.
Chris, thank you very much. That was an excellent answer, and people should heed that as well. That's the end of our webinar today. We have no more time for questions, but I know there are some questions that have been raised. On the screen, you'll see the various presenters and their contact information. Please feel free to reach out directly to them with any questions you might have. We'll be glad to answer them. There'll be a recording of this. There is a recording of this webinar, which will be distributed along with the slides. You'll see that. And we appreciate your listening today, and hope you've taken away some helpful things that will help you in your business going forward. Thank you very much. Goodbye.